Well, welcome everybody. This is the nuts and bolts client and trustee training presentation for 2014 for disability. And I want to let you know that this is a brand new presentation. This is not in the same format that we've had before. And we hope that this one is a little bit more client and helper friendly. And that you'll find this useful. This is going to be recorded. It will be on our website, uploaded there, and so all of our clients and their helpers will have access to it from our website. So the first thing that's different is that I can't seem to progress this along, all right? So hold on a second, folks. Interesting. Well, I'm just going to show it this way. You'll be able to see the slides in any event. So again, I want to welcome our clients and our helpers. Typically, we have addressed these programs just to our clients. And now that we're online, we're doing this so that the helpers can have more access to them. And so this program is going to be directed both to the clients and to the helpers, so that we'll be talking to both sets of people. The website, and Joe asked me to mention this, if you go to our website, heritagedesignlaw.com, and by the way, notice that there's no www there on the website name. It's a secure website, so that you don't need to put that in. And if you, on the lower right-hand corner of the website, there is a login screen, and if you want to log in, then you type in as a username Step2 member, and then as the password, you type in program 2014. There are no capitals in either of those words. So you can log in. You'll come to our Step2 clients page, and you'll see the resources that are there, of which there are quite a few currently, and we're adding as we go along. There are a number of resources that we'll be mentioning in this program that are not on the website yet, but between now and the annual client meetings in June, we plan to have the website upgraded so that we have a lot more of the materials that we'll be talking about. One of the things that we want to do is have what we've normally called the Blue Book. We can also refer to it as the Operator's Manual in downloadable form on the website, as well as something called a Helper's Handbook, which is a somewhat modified version of the Blue Book for download by the helpers so that they will have the information as well. So between now and the annual client meeting, we're planning to have that on our website. So hopefully by the time you see this, you'll already be able to get into the website and see all those other things that I mentioned during this presentation. So typically we've talked to the clients about what their goals are and what their goals are for the nuts and bolts program in the education, and what they typically tell us is that they primarily want to make things smoother and easier for those that follow them. The purpose of the Step 2 program is one of them is to provide education to people who we call helpers, and these are people who play various different roles, which we'll be talking about today, in our clients' estate plans. So what the clients are doing is that they want to make sure that that estate settlement, whether for disability or when somebody passes on, that the estate settlement will run smoother and easier for the people that follow. So, but we have some goals ourselves for this program, and these are the goals that we have for the clients. I'll talk a little bit in a minute about the goals that we have for the helpers. And by the way, I just want to say that you know, there's good news and bad news today. The good news is that this is a brand new program. The bad news is that this is a brand new program. It's the first time we've given it, so I may go over a little bit, or this may go short in the 1 hour, but I hope you'll bear with me. So for the clients, in terms of the education that we're doing today, one of the first objectives that we have is to help them have a better peace of mind, so they know what's going to happen, they know what the types of things that can happen, and that we also want to help them reinforce their current commitments, because all of our clients sign commitments when they start with us, and we're adopting a practice of having all of our clients re-sign the commitments and restate the commitments every year at the annual client meetings in June, so that everyone has proper expectations and knows what to expect. Because as we tell everyone when they begin the planning with us, most estate plans don't work. By that we mean they don't meet people's expectations, and one of the primary reasons for us doing this education is to make sure that everybody's expectations are on the same page. Another thing is to help clients evaluate their helpers and who they've selected, so they have a better idea of what the helpers' roles are and who would be in the best position to do the kinds of things that we'll be explaining today. And of course, it's designed to help our clients have a better vision of the impact of their planning, or the lack of an impact of their planning, for their own thoughts, and so that they can upgrade things if they want to, or make changes if they want to. We want to discuss the concrete steps that we can take to make the process better for your loved ones and the people that follow, so that you know during your lifetime exactly what you can do to proactively to make things run smoother. And of course, we want to motivate you to get your loved ones involved now, because when the loved ones and the people that follow you are not involved and don't have the conversations that they need to have with you, then what happens is they do not know what to expect, and it becomes something of a nightmare when they have to deal with all of these issues. For the helpers, we hope that the helpers who are watching this program will share with us what their real goals are. And there's a number of different ways for them to do that. The first is what we call the First Call program. By actually attending this program, you qualify yourself for what we call the First Call program. And essentially all that means is that you can call us, and particularly me or Christine Elsmore, our associate, anytime you want. And if we can answer your question on the telephone, its clock does not get turned on. If it turns out that it turns into a project and we need to deal with fees, then we'll let you know. But the First Call program is designed essentially because people often don't make that call because they're afraid they're going to get billed. And all of our Step 2 clients and their helpers who attend these classes have the ability to just call us and ask us questions as time goes by, and we're very happy to answer those questions based on our experience. Of course, anyone who's a helper can send us a private email. Let me just give you my email address. It's fbridges@hdlawgroup.com. Note that the .com for the email is different from what the website's .com is. When we did it, we decided that it was much too long to type heritagedesignlaw.com in an email address, so we tried to shorten it. And so it's HD as in deliver, lawgroup.com. So also, of course, on the website, once this is recorded and we're able to upload it, we'll also be having, between now and the client meetings in June, we'll be having an evaluation form on the website. The evaluation form is something that you will download from the website and fill out. There'll be a couple of questions about the presentation on the evaluation form, but we also want to have your feedback, and that's how we know that you've actually attended. We will notify our clients that you have, the client that you're associated with, and then you'll qualify for the First Call program. So that's sure, Joe.
The very phrase "first call" indicates there's no second call. Is that true?
No.
Okay.
There are any number of first calls. It means that
Okay.
we want you to call us first before you make a mistake.
Okay.
Okay?
Thank you.
And thanks for breaking in and clarifying that for me, Joe. And of course, just let us know what's working for you and what's not working. You can call us, you can send us an email, give us the information on the evaluation form, and that'll be very helpful for us. So we have some goals for the program for the helpers ourselves. Of course, we want to familiarize the helpers with the disability process, and we want to build your confidence in the process so that you understand that there is a process and that it will work. And that you can feel more comfort in what's going to happen when the time comes. We want to explain the commitments as well to the helpers and to set the proper expectations. And we want to prepare you for the issues that you're likely to face when you're helping your parents or other loved ones during periods of disability or after people die. But today we're talking about disabilities, so there'll be a number of issues specifically discussed today that we want you to understand how you're going to face those. And of course, in that connection, we want to provide you with an overall overview of all the tasks that are going to be performed if disability strikes, and to encourage you to be proactive in discussing all of these things with the people that you're helping, with our clients. The fundamental problem that most people have is that nobody ever really talks about what happens in disability, and we find that when people actually do talk, things go a lot smoother. People are a lot more satisfied with the arrangements that people have made, and it helps people be able to help their clients better. So we want to let you know how you can help our clients prepare better for the various different types of things that can happen. So there are a number of proactive lifetime steps that our Step 2, our clients can do. And remember that this is Step 2 in what we call the 3-step strategy. The first step is to establish your plan with counseling-oriented planning partners. The second step is to commit yourself and your loved ones to a formal and continuous maintenance and education program. And the third step is to secure appropriate assistance to transfer your wisdom along with the rest of your wealth. And so what we are right now is in the Step 2 program, and the Nuts and Bolts program is part of the education component of the Step 2 program. That's why we call it Step 2. It's the second step in the 3-step strategy. So one of the things that clients do initially is that they do funding. And what we mean by funding is we change the title to their assets so they line up with the instructions that they have in their estate plan. And so it's important. There are 3 different types of trusts. There are fully funded trusts where all of the assets are aimed toward the trust, and the trust controls what happens to them at various different phases of time. There are partially funded trusts where some assets are aimed at the trust but others are not. And there are trusts that are not funded at all, and those are trusts that we often call bare bones trust, the result of which is that the trust instructions don't actually apply to the assets that are outside of the trust. So in order for clients to actually have their instructions that are in the trust apply to the assets, they have to make sure that the trust actually controls those assets. And so what we do when we begin our planning with clients is that we do what we call a funding project. But over time, people change their assets, they change institutions, they make changes in their financial circumstances and their personal circumstances. So it's also very important that the funding or the titling of the assets actually is up to date. So part of our Step 2 program is every year our clients give us an updated review of all of the assets that we have on record and how they're owned and what their current value is, so that we make sure that all of the assets are fully funded. Sometimes when people do estate settlement, either for disability or death, we find that we don't actually have confirmation that some of these things are actually funded into the trust, although we make the assumption that they are. And what we want to do is to make sure that we have confirmations, because sometimes it happens that we think things are confirmed and think things are in the trust, and then when it comes to actually looking at it, we discover that they are not actually confirmed, and titled the way we gave instructions to do, or instructed financial institutions to do. So it's important to make sure that we get all of those verifications, and that's part of the annual updating program for funding. The second thing is that the clients can communicate what they want, what steps should be taken now, rather than have their helpers discover what's supposed to happen when everything's running along on a fast conveyor belt and they don't really know what's supposed to happen. So communicating what to do now is part of this program. It's part of what we're doing today, and it's part of the proactive steps that our clients can take. All of our clients have what's called a red book, and that has all of their current documentation in it. Every year we update it. Every other year we update all of those documents and substitute the current documents for the prior documents in the red book. As part of the red book, there is a location list, and that is a list of all of the various different things that are important in the estate plan and where they are actually stored. So, for example, the location list might have might describe the specific living trust and where the original is stored. And so the location list is a form that's in everybody's red book, and we ask them to make sure that they fill that out. One of the key elements of that, of course, is passwords. Everybody now, in order to get access to bank accounts and a lot of other places, everyone has a lot of passwords. I know that I have a brand new program myself that I've downloaded onto my iPhone to make sure that I can keep track of all the various different logins and passwords, because there's so many it's practically impossible to keep up with them without having the record of them. So it's an absolutely secure application, but in order to actually keep up with those, it's important. Now, when somebody becomes disabled, for example, in order to be able to get into their bank accounts and that kind of thing, their helpers need to know where those passwords are and what they are. So if the location list has a description of where a list of those passwords is stored, like in the safe or in a safe place in the house, or even in the red book or some other place that the client regards as secure, that would be really important to help the helpers proceed with the kinds of things that they need to do, because otherwise they just won't have access to a lot of things they have to have access to. And of course, one of the most important things is to keep us informed of who the helpers are and their beneficiaries. Of course, we know who the helpers are on a biannual basis when we update all the documents, but keeping their current information in terms of their contact information available to us and keeping it updated is extremely important for us, so that we can contact people when they need to be contacted, and so that we know that we are able to be in communication with the people that our clients need us to be in communication with. So there are a lot of different proactive steps, and so there's more here. One of them is to consolidate investments. We find often that clients come to us with a number of different investment accounts, and so that needlessly complicates the funding project. And you'll see today that when we, I got to put my phone on do not disturb. You'll see that when we actually do disability estate settlement, it can be a lot more complicated if there are a number of different accounts, and essentially if we have a lot of paperwork and separate accounts, that can make things more difficult for the helpers to get things done. And of course, a lot of our clients, and this doesn't happen so much anymore, but a lot of our clients have certificated securities, which frankly over the last few years since we began doing this, we found to be kind of the bane of our existence in terms of funding, because there was a lot of different steps that are required in order to change the name on a certificated security. Most clients now have what are called street accounts. That's a brokerage account or some kind of account with a registered investment advisor, so that they have the ability to transfer the account itself, and that can be done very, very easily and quickly. Also, of course, one of the things that people really do not talk about, and that is the personalized healthcare instructions that they have. And we'll go over what this really means in a few minutes. But it's really easy for people to have personalized healthcare instructions, but if they don't actually communicate them to the helpers who are supposed to carry them out, then it's not worthwhile to have actually done the documentation. So actually discussing the kinds of things that our clients want with their helpers is one of the most important parts of disability planning. In our initial, just one thing, I'm going to, in order to make sure that everybody can hear, I'm going to mute everybody. If you have a question, you can look into the chat box on the right-hand side and make sure that you can type in. So continuing on now, what we say in our introductory session is that, which we call the Truth About Estate Planning for new clients. We tell them that it's important for people to have an idea of what they want to have for long-term care, whether they want to stay home or go to a nursing home, but we don't ask them what it is. Everybody has an opinion, and the reason that we do that is that we're talking about a document that doesn't actually have any instructions in it, the healthcare proxy. And so we tell people that it's almost more important to actually discuss what we want to have with the people than simply to have the document. But of course, isn't it better to do both? So actually having those discussions is really an important part of disability planning, and we try to help our clients take care of that problem. Care Call is another service that we have for our Step 2 clients. Care Call is an online program. It's designed primarily to provide emergency notification in the event of some form of accident or event where healthcare workers are trying to find out who the people are that care about you and that they need to contact in the event of some form of accident. And so what Care Call does is that they verify who the healthcare workers are, and then they'll make the calls that you have told them in advance to make to the people. And they can even call your neighbors to make sure that your dog or cat is taken care of if that's necessary. But that's we'll talk a little bit more about the Care Call service in a while, but make sure that you go to your Care Call account. Everyone has one. When people do our estate planning with us, we set a Care Call account up for them, and they're updated every year. But sharing those Care Call accounts with your helpers can be a very important thing proactively, so that they know where that information is, particularly for medications, it's that kind of thing. And then, of course, discuss the participation in settlement with the various different helpers, and so that everybody understands what their role is and why they've been given that role. So, and of course, the most important thing is to make sure the helpers and beneficiaries get the proactive training so they really know what to expect. We've taken to calling the training for the beneficiaries and helpers, particularly for the beneficiaries, by the name of wealth reception planning. So that's, in other words, training the beneficiaries about how to be the receivers of wealth, and so that they understand why people have done the planning that they've done and how they can do that. So there are 4 goals for today that we want to make sure everybody understands. The first is to know the law firm's name and how to contact us. And the second is to remember that there is a process, not necessarily what the process is, but that there is a process, and that the process produces the results, so it's important to follow it. We have something called the parking lot rule that is almost universally true. If you go to a presentation, by the time you get to the parking lot and open the door to your car, you've lost most of the presentation. The information in the presentation is gone from your mind. I know that's true about me. And so it's really important just to remember the key things, which are one of which is that there is a process, and it's the process that produces the results, and that we should have confidence in. We want to also give you an idea of what the types of issues are that you're going to deal with, and we want to encourage your interest in planning participation with, if you're a helper, to participate in the planning with our clients. So I want to talk about a few key concepts. The first is the Heritage Protocol Design Template. Now, the Heritage Protocol Design Template is actually a form that we use when we make when we design plans with our clients, and it looks like this. So this is the first page. It usually has multiple pages. The rest of the pages deal with what happens after death, but this is the first page and what happens during the lifetime of the client. So we talk about with the client when we do the design what happens in connection with their living trust while they're alive and well, who their family is, how their trusts are funded. We talk about how the control is and why that's important and that they keep control. We talk about who their trustees are. Usually if it's a couple, it's both members of the couple are trustees of each other's trust. And then we talk about what happens during disability. So it's important to understand that there's one of the main goals is that there be no living probate, but that only happens if the trust is funded, and that what there is in order to, one of the triggers that actually determines how things actually operate is something called the disability panel. We'll talk a little bit about what that is, so that that can be the panel members can be the medical people or family members, and the clients control how that actually happens by providing the test and the people who are going to make that decision. So, you know, our clients we're talking about a time when the clients might not actually be able to be in control because they are disabled, but the way that they control that whole process is that they name the people that they trust to make the decision that they're not able to handle their financial affairs, and those could be medical people or family members, and that they explain what the actual process or actual test is in their trust documents, so that once that determination is made, there are successor trustees that they have designated, and that's who over here actually take over the administration of the financial affairs. Remember that disability determination in a trust is not the same thing as an issue of competence, although they're common issues. We're primarily concerned with whether the client can actually effectively manage their financial affairs. And that's essentially what the trust is about. A lot of this is all about finances. So that's the template. So you can see that there is a design that goes on for the clients over a period of time when they do their planning, and sometimes clients come in and actually decide that they want to make some changes in that. We use the design template again. Some of our older clients had a different design template. The one that I'm showing you today is actually one that is used throughout the National Network of Estate Planning Attorneys, of which this firm is a member and has been a member since 1996. You can see on the right-hand corner down here that the National Network is the progenitor of this forum, and there are about 300 to 350 lawyers around the country who practice pretty much the same way, have Step 2 programs, use the same designs and the same software. Obviously, every client's plan is customized for them, but we have our methodologies and our processes, and this is the template that most of the members of the National Network actually use, with some modifications for local purposes, in preparing and designing their plan. So we use this as licensees of the National Network. So when people are actually making the determination of how they're going to be decide how the disability determination is going to be made, we actually have a new tool that we've begun using with our clients called the Disability Determination Developer, and that's what this is. Now, there could be medical input and there could be family input into into the issue. And so what we're talking about here with clients is, with whom do you feel most comfortable in making that kind of decision? Is it your primary care physician? Do you want to have a second opinion by an expert? Are there family members or friends that you would trust most with this? And so the scale of how confident people are from 1 to 5 is what we talk about in terms of that thing. We do find, however, that many of the medical professionals do not want to be part of the committee or the panel that makes the decision, although some of the clients want them to do that, because they don't like to be responsible for financial consequences of their medical decisions or medical advice. But depending on the closeness of your relationship with your primary care physician, that may be different. We would recommend that people who are using medical personnel to be part of their panel of people actually review that role with the doctor, so that the doctor is aware and understands what they're actually doing and indicates that they're willing to actually adopt that role. And some people want to have a second opinion by an expert, and so the issue then is, by doing that, what is the scale, on the scale of the, do you feel by doing that you're getting a lot of protection, or does that feel like that's a lot of extra complexity? So, and then of course we talk about who the family members might be, and whether that decision is going to be made by a majority of the members of the panel or by unanimous decision of the panel. So, and we also suggest that who the family members are might be successors as well as successors. Most people who are married have spouses. If they have adult children, often they will have all of their children on the disability panel. Typically, we suggest that it be at least 2 or 3 people, not just one, and that at least one of the members of the panel not be a successor trustee, so that there is third-party credibility. And the reason for that is that actually once we begin the funding process for disability or upon death, we're using a certificate that is signed by the members of the disability panel to actually do the funding, to persuade the institutions and third parties that title to the assets that are held by the trust should be changed to the names of the successor trustees. And this is a process that our clients have adopted so that they know that they control how that actually occurs. And so the purpose of that disability certificate is very much like a death certificate, in that it shows and it's signed before notaries, and sometimes we have people take it to banks so that it can be verified by the bank. And we use that as part of the process for actually doing the funding. When we do funding, many of the institutions ask for a copy of the trust. Instead, we like to provide them with something we call the trustee or the trustee affidavit, which has the provisions in the trust in it that the banks or other institutions need to see, so that they can see who the successor trustees are, they can see what their powers are, but they don't need to see the individual provisions in the trust. And we find that many of them ask for the trust, but then keep only the first and last pages of it, discarding the rest. So we like to give them an affidavit. When we're doing the funding to change title to the trustees when someone becomes disabled, we're actually using the affidavit of trust that the client signed along with that disability certificate, so that the banks and the institutions can say, okay, now we see that you are actually the person who should be on that account, and we're happy to make the change on that account. So developing that determination is something that our clients spend a lot of time on when they do their initial design. And it's something that they should discuss with the people who are the members of the panel, because the panel members are helpers and they should understand what their role is. I had one case where a sister was actually designated as a panel member, and when it came time to actually make that determination, the sister refused because she had it confused with making a determination of incompetence, which was a completely different issue. So we ended up having to have her satisfied the determination of a doctor, even though the doctor wasn't on the panel. So it's important to actually communicate what that role is to the people who are your helpers, who are panel members, so that they actually understand what their role is. So once we have that, there is a disability process, and I want to show you something called the disability process arrow. So here's how that actually moves forward. This is really a kind of a description of the basic process that we go through when someone becomes disabled or is in the process of becoming disabled. And the first thing is that the people who, when someone is having a problem like that, what happens is the family usually rallies around them, and that's a wonderful thing. One of our biggest frustrations, though, is that they don't call us. So that, that's one of the things, that's the first call, Joe. That's what we want people to do, is make that first call so that they can notify us that there's been the onset of that disability and that there may be a problem. Once that occurs, we typically have a disability teleconference so that we can discuss exactly what needs to be done and whether anything needs to be done right away or whether it's something that's going to happen down the road. And then once that occurs, when it's clear that the disability panel needs to be convened, we will typically have a disability counseling session. Depending on where people are, they might come into the office, or you might do it by GoToMeeting such as we're doing today. And we have that counseling session so that people understand what their job is, what they're supposed to do, and why we're doing it. And then, of course, over here, D, the disability panel, makes that determination and signs the disability certificates. And once that is done, the new trustees, the disability trustees, their job is to take over, and we have to do the asset transfer process so that they can actually be in control of the assets that they hold as trustees of the trust. So that's the basic disability process. Now, sometimes there are situations where people need to deal with Medicaid. And so there's a Medicaid qualification process. So here's what that process looks like. This is a little bit longer. It begins with the same kind of process for disability as we have. And as most of you know, we don't typically do a lot of Medicaid planning, and that involves a Medicaid application. So we typically refer that out. So the process looks like this. We want people to contact the law firm and tell us of the onset of any disability, and then we complete that disability process that we just showed you, so that the successor trustees are in control and decisions can be made about how things are going to be done. Typically for Medicaid planning, it's important to get assets outside of the trust because otherwise we might not avoid the spend down. And so we typically then what we do is we refer the family to an elder law attorney that we work with. And by the way, later on this summer we're going to be having a Medicaid session like this, and there will be an elder law attorney on that session with us. And then, of course, we do the asset control transfer and make sure that we get everything in place. And then, with the advice of the elder law attorney, we begin the asset repositioning process. So the elder law attorney will provide us with some advice about how the assets should be held, and then we'll begin the process of retitling those assets. Either the elder law attorney will do it or we will, so that then the Medicaid application process begins, so that everything's positioned properly so as to minimize the Medicaid spend down requirements. So that's the disability process for Medicaid. Now, there's also a disability process when someone discovers that they have a terminal illness, because, someone who has a terminal illness, they're not necessarily financially disabled, and so it's important for them to actually communicate what they really want to the family, and this can be a very, very rewarding and helpful process. So if someone does get a terminal illness, what we want to do is we want to arrange a family meeting so that everybody can be sitting around the table and the client can actually talk about excuse me, the kinds of things that they want to make clear to their family and as to what happens, etc. I recently talked to another colleague who had this kind of a process happen, and they had a wonderful meeting. They left the meeting, and the helpers actually said, you know, I've never been to a meeting in a law firm where I actually came away feeling much more safe and comfortable. And so the family was able to get together to have conduct the family meeting and have those personal conversations that the client wanted to have. And unfortunately, the client, who had pancreatic cancer, as I believe the story goes, died 2 days later. But they were able to have those conversations and begin the implementation of the kinds of things that the client wanted to have. So that's important, even for a terminal illness, that someone notify us so that we can help prepare the family and the helpers for what's to come and actually make the process a lot more comfortable for people. So those are some of the key concepts that it's important to understand. So let me just talk about the definition of estate planning. This is something that we go over with our clients, and this is essentially how our clients approach the whole estate planning process, and it goes like this. I want to control my property while I'm alive and well, and we frankly don't have any clients who don't want to control their property while they're alive and well, and that's one of the reasons why we do the planning that we do, because it does actually optimize their control, particularly, for example, with the disability panel. And second, I want to plan for me and my loved ones if I become disabled. And what I mean by that is that I want to be able to have things done as they would be done if I were able to do it myself. So I want to plan for me and my loved ones and make sure that everything is taken care of and give those priorities about how things should be spent and who should do it. And you saw that in the design template. That's exactly what people are doing when they're doing that. And then, of course, for estate settlement, I want to give what I have to whom I want, when I want, and the way that I want, all while assuring that my wisdom is transferred along with the rest of my wealth. And we also review with the clients the estate planning pyramid. You know, most people understand that, you know, the easiest part of the puzzle is actually saving taxes, and most of the attorneys, and I'll say that I did this myself, begin the process of estate planning with saving taxes in mind. But actually, that's the easiest part of the whole puzzle, and what we like to do is make sure that we understand who the client is and who their family is, so that we have a better understanding of the kinds of activities and what their roles are and who would do what best to begin with. So the first part of what we do when we're doing our planning for the estate settlement, for the planning, is using the planning pyramid here, is we begin with the individual client, and then we talk about their family. So it's important to begin with the end in mind and to make sure that the primary thing that's important be done. So we've talked about the design template already, and you know, that's planning for the financial and health care decisions during disability. So let me just take you quickly to that template again, just so that I can be more specific about the kinds of things that we're talking about. So when the client is doing their planning, they have decided that they don't want to have a probate, so they know that the only way that's going to happen is if their trust is fully funded. They've made a decision about who it is that they want to make the decision that they can't handle their financial affairs. That's their way of controlling how that happens, and that's going to be either medical personnel or family members or a combination of both. And then what they do is and the who is the trustees, and notice that there's the word co in here. We often make sure that someone who is a disability trustee, for example, many times it's the spouse of the person who's disabled, and they're spending a lot of time taking care of the person. You know, they might be taking care of the person in the home, or they're traveling back and forth to a nursing home, whatever that might be, and so they need someone as a co-trustee to kind of help them. It's a great comfort to someone who is the spouse of someone who's disabled, who has all of the other stuff to do in terms of taking care of their spouse, to have someone as a co-trustee who can deal with some of the financial affairs as time goes forward. And you know, sometimes we have several trustees or children, and spousal control means that if the spouse decides, even though there might be 2 or 3 other decisions by other people, if the spouse makes a decision, the spouse controls the majority. And if the co-trustee is acting out or isn't behaving properly, the spouse has the right to fire the co-trustee, and successors are actually named in the trusts to take over that position. And then, of course, one of the primary important things is to provide instructions about what's supposed to happen if the client is disabled, and that's what we mean here in the priorities. So what bills to pay, how to pay them, who the beneficiaries are while I'm disabled, and that kind of thing. Then, of course, we have a number of different powers of attorney, and those are down here. Now, remember that when we fully fund the trust, all of the assets are either aimed at or in the trust, but there are certain assets and certain types of things that aren't controlled by the trust, and we're going to need financial powers of attorney. So down here we have the first one is what we call the funding power of attorney, and this is a power of attorney where a person says these people have the ability to transfer property to my trust. And if you think about that, that's a power that you could actually give to just about anybody, because the only thing they can do is transfer property to the trust, and the only person who has the ability to amend our client's trust is the client. So giving someone a funding power can be very helpful, particularly if the client has forgotten something and they're disabled. That means that they can have help. The limited and miscellaneous power of attorney is also something that I should notice that this says that it's effective immediately for the funding power. What that means is that the power of attorney is actually in effect as soon as you sign it. Typically, we have, on a traditional basis, not recommended that people sign powers of attorney other than the funding power as a general power of attorney that's currently effective, because the typical problems with those are that a power of attorney has no instructions in it, the agent has no accountability, and we can't think of any way that you could define lack of control better than saying, there are no instructions in the document, the agent can do whatever they want, that's within the terms of the document, they don't have to account to anybody, and so third parties often have trouble with that, but we generally recommend against that. So our powers of attorney, particularly the ones that have the most of the main powers, which we typically call the limited miscellaneous power, it's been called some other things too, actually gets triggered when the disability panel makes their determinations. So if someone is appointed under a limited miscellaneous power of attorney, the way they actually take control of the kinds of things that they're supposed to do is that they attach a copy of the disability panel certificate so that activates the limited miscellaneous power of attorney. So it's effective only when the client becomes disabled. And there are things that we can't control by the trust. So for example, one of them is retirement accounts. If we actually funded the assets in the retirement account into a client's revocable living trust, that would mean that was a distribution from the retirement account, and that would be a taxable event. All of the assets in the retirement account become part of the trust. So that would be an income, all of that would be income taxable. So the retirement account is actually in the client's name, which means that the trustees don't have any control over what happens in terms of investments or distributions. And so the person who has control over that would be someone who is appointed as a power of attorney, as an attorney, in fact, for the client. So that's one of the things that a person who holds the limited and miscellaneous power can do. And they can continue a gifting program if there is one, and run errands, for example, dealing with Social Security, or even dealing with Medicaid and that kind of thing, third parties that need to have some kind of thing, some kind of individual activity other than a trustee. Over here in the healthcare decisions, typically, we have the state and constitutional, dealing with the living will. That's usually for a terminal condition or irreversible coma, persistent vegetative state, or severe dementia, that kind of thing. And if you think about it, the client you might put in the position of the president. They're making the ultimate pronouncement in their living will about what they want to have happen if they can't, in terms of the termination of their life, and they don't want to be expensively maintained when there is no quality of life. But the person who is appointed as the person who's going to be their healthcare proxy in Massachusetts, they are sort of like the Secretary of State. And they say, well, that's what they said, but here's what they meant. And so all those medical decisions get done by the person who is the healthcare proxy in Massachusetts. And of course, the HIPAA, everybody knows about a HIPAA waiver. We typically have the HIPAA, which is to preserve privacy. We typically put in our client's HIPAA waiver, which they sign every year at the annual client meeting. Not only the person who has who is the healthcare proxy, but also other people in the family who have health-related decisions, such as the disability panel. So that way they can talk to the doctors and the medical personnel, and all of those privacy issues don't become an obstacle for them actually being able to talk. Now, also that we encourage our clients to have instructions, and we'll talk a little bit about that in a few minutes. But those are the kinds of determinations. Now, there's over here you'll also see a general power of attorney, and I'll go into that in a couple of seconds. So let me get back to the presentation. So the helpers' roles are to be participants in the disability panel, and they decide whether the client is financially disabled. There's the health, which I've explained what their decision is. Then there's the healthcare representative, or the healthcare proxy. That's what we call it in Massachusetts. They make the healthcare decisions, but notice it only happens if the doctor decides that you can't. That's the law in almost universally in all the states, that the healthcare proxy does not get any authority to make healthcare decisions for the client unless the doctor decides that the client is not able to make healthcare decisions for themselves. Now, in Massachusetts, we have to have one healthcare representative, which oftentimes becomes a problem for our clients because they want both of their children or all of their children or several of their children to act equally. So in Massachusetts, we have to have only one. The medical personnel appreciate only having one spokesperson for the family, but you can notice over here in the design template, we have this instructions right here. And what we're referring to there is that the client should actually set forth some instructions about how the healthcare agent should consult with other people in the family, so that everybody gets together and there's a consensus and nobody feels left out of the process. So then once the disability trustees have the disability panel has made its determination, another helper role is the disability trustees, and they handle all the assets that are titled in the name of the trust. And then, of course, the agents under the powers of attorney handle financial decisions on assets and things like that that are outside of the trust and the errands. So we've talked about the disability determination developer, and I just want to show you here that, during the time of the lifetime of the client, they have a RLT, stands for Revocable Living Trust, and at some point they often can become disabled. And so we have the definition of how that actually occurs, what that actually means. Typically it's I'm disabled if my disability panel determines that I'm not able to handle my financial affairs effectively. And so that's what the panel is taking a look at. Typically we recommend that the panel members be people who are familiar with the client on a day-to-day basis so that they can notice that there's a problem. And once that's done, the client actually determines what the priorities are and who's going to carry that out. So we've talked about the powers of attorney, and of course the disability powers of attorney become effective when the disability panel signs those certificates. Now, a lot of helpers are going to actually be acting once that decision is made in two capacities. One as a successor trustee, and one potentially as holding a power of attorney or an attorney in fact. And so from a financial point of view. And there's an old story about how, politicians, for example, if they have two different state universities, like in Florida, a lot of times they can't take sides when they go to a football game, even though they want to go to the football game. So they often have a hat that has one state university on one side in the bill of the hat, and then on the other side they have the colors of the other state university. So oftentimes people are actually operating with a two-sided hat. And so it's important for them to be, impartial, perceived to be impartial, and so they actually have two separate roles. So the disability trustees handle the assets that are titled in the name of the trust, and the agents deal with what happens to the assets when they're outside of the trust. Now, note that the funding power is effective immediately, and that's important because if someone is going to help the client at any particular time, we can't be having the disability panel make the decision. Effective immediately means that if the client goes away on the trip, the people who hold that power can continue to do signed documentation to make transfers of assets. And then, of course, the limited miscellaneous power becomes effective when someone becomes disabled. After consideration, we determined that it would be very helpful for Heritage Design Law Group also to be on the funding power agent. And that helps because a lot of times there's a hassle. If there's an emergency in a terminal situation, it's important to make sure things are done very quickly, and the clients and their helpers often don't have time to deal with the paperwork. But of course, we do not have access to the funds, and no particular individual is granted the power. The power is held by the firm, and the only thing that we can do under the power of attorney is transfer assets to the trust or designate the trust as the beneficiary, for example, of life insurance, in accordance with the client's instructions. So based on the successful use of the funding power, we determined, and I showed you the general power of attorney. Typically the problem with springing powers, or powers that become effective when you're disabled and there's that determination, is that we often need help. For example, if we make a trip, go on a trip, or if we're injured in a hotel, or I'm sorry, in a hospital, and we need some help taking care of some things, having people do some errands with us, we don't want to have the disability determination done by the panel. We want to remain trustees who may be completely competent to handle our financial affairs. We just might need some help. So more recently we began having clients actually sign what we call a general power of attorney, and what we do is we place that power of attorney in escrow. And I showed you that on the design template, for example. And so here it is. It's in escrow. The general power of attorney is held in escrow. And that gets rid of the primary objections that we had to powers of attorney having, being blank checks. They have no instructions and no accountability, and, dealing with the issue of control. So now what happens is that the client can call us if they need some help, and we can help them in the process of actually dealing with the kinds of things. We release the general power of attorney to the person who is named so that they can then go along and we don't have to go through the disability process. And that protects the clients so that it's only used when they actually want to have it used and need it. There are other powers of attorney that can be provided to allow a helper to be only on a particular bank account to help clients with real estate transactions. In Massachusetts, we have the ability for, let's say clients are going away, they want to appoint someone to be the temporary guardian of a minor child who's going to stay home. Those are kinds of powers of attorney. Massachusetts allows that to happen now. We didn't used to have that. And so those are kinds of powers of attorney that can happen. And then, of course, there's also the other legal documents. There's the living will that deals with what happens in the terminal situation. And we recommend that our clients actually really discuss what they want in that circumstance with their helpers so that everybody understands and is on the same page. And of course the healthcare proxy and the HIPAA waiver. The healthcare agent under the healthcare proxy is the person who actually instructs the medical personnel to turn off the machines, etc. And of course they need to have a lot of support, so that's why we have clients sign the living will so that they know actually that they are instructed to do so, and that's okay. So in order for all of that personalization to take place, we recommend that the clients actually go through for their own health care. You're going to see this on the website, and we'll provide it for you on the website, a checklist of the various different decisions that clients want to have made, how they want to have them made, so that and it's a fairly lengthy document, so the clients can actually go through and say, I want my healthcare agent to consult with my family, or I don't want them to consult with my family, depending on who's a good decision maker in those kinds of circumstances. And also there's a document called My Life, My Choices. It's a book that's prepared by an organization that we respect a lot. And this allows people to actually go through a lot of the decisions and a lot of the types of determinations that people need to make for medical purposes, so that they have actually dealt with a lot of these decisions before the time comes when they have to deal with them. And it helps them actually be able to make those decisions, understand what the issues are, and communicate them to their helpers. And remember, I talked about the care call service. Be sure that you understand what their login information, customize your account by going in and inputting whoever you want to have called and that kind of thing. You can provide information about medicines and allergies there, so that's a very good service. One final thing is that I want to talk about the Trust Protector. We began inserting provisions for a Trust Protector in our clients' trusts a few years ago. Here's what a Trust Protector is. They're a third party who can make modifications to the trust, and they can make the modifications when the client is disabled, or after the client has died, or after both spouses have died. And so, that's an important thing, because once you become disabled, you can't make changes in your trust because you're no longer able to do that. And the only person who can make amendments to a revocable trust is the client, other than the Trust Protector. But there's a lot of restrictions to how we would do that. The Trust Protector can't be related to you. They can't have any interest in the trust. They should have a strong understanding of the law. They should have a strong understanding of what the trust document itself says and what it means. And they can only make changes based on the client's intent. That's all set forth in the document. So the document actually says the trustees, the beneficiaries, and even a court can appoint a Trust Protector to review the trust and see whether changes need to be made based on circumstances, changes in the law, that kind of thing. And these trusts can be in effect for long periods of time, and the law does change, and it can affect how the trust is interpreted and actually operates. So having a Trust Protector actually make sure the trust continues to operate the way that the clients want it to operate is really important. Who might that be? Typically clients say, well, that would be the law firm. Remember, it can't be related to the client. They need to have a strong understanding of the law and of the trust document. But how does the Trust Protector know what your intent is? They can only make changes based on your intent. So how does the Trust Protector determine intent? Well, when we do our planning together, we set forth everyone's estate planning goals. We have the design template, which I've showed you. And every other year, our clients sign restatements of their trusts. So we have some clients who began doing their trusts in 1998 or 1999. We have a couple from 1996, and they've been signing restatements almost every year ever since then. So we understand what clients want. In order to make those restatements, we have clients sign what's called an Estate Planning Review Worksheet, or EPRW for short, and that's where the client reaffirms all the various different customization decisions, who's going to have what role, how distributions are to be made. And another way to do that is for clients to sign a memorandum memorandum of intent. This isn't something we have done in the past or we're beginning to do now, so that the clients can say, I want my my family to be protected, but I want to save taxes, that kind of thing. I don't want creditors to get into the trust and take the assets, etc. So those are the kinds of things that would be intent that we'd want instructions on. Much of the intent is documented due to the Step 2 program participation, and that's through the updating. Now, one thing that we've realized lately is that, we can continue the client's participation in the updating program through the use of the Trust Protector, even though you're disabled. So how does that work? Well, if you are disabled and you've appointed a Trust Protector, or the trustees, successor trustees have done that, and we're updating documents in a particular time, why not have the Trust Protector actually sign your document for you to update them, as long as we're not changing the dispositive provisions, we're just keeping it current with the law. And of course, providing a supplemental memorandum to the Trust Protector that we request that we do just that is something that we'll be talking to clients about this year in the annual client meeting. So the disability trustees can also decide to continue the Step 2 program participation, so that the Trust Protector steps in and signs the restatements for them, so that the things are updated on an annual basis, because some of these disabilities can last for very long periods of time, decades in some cases. So it's important to make sure that those documents are updated on a regular basis, so that the current changes in the law are actually dealt with, consistent with the client's intent. We think that this concept is critical to the beneficiary's inheritance planning, so that they understand how things are supposed to go. We have another presentation that we'll be introducing later this year about how beneficiaries can maximize their inheritance and deal with get some training about what it's like to be a beneficiary. And the Trust Protector can allow continued updating for long periods of time. And also it can continue updating the trust even during the beneficiary's life, so that if there are changes in the law, the beneficiary, the trust can be updated even beyond the time that the client and their spouse has died. So what to do in terms of the disability? What happens? The first thing, at the first sign of concern, call the law firm and begin the process and receive the initial guidance that's necessary. Follow the Heritage Design Disability Process arrow from there, those are the primary things that we want people to do. So we've talked about the disability process arrow. We've talked about the Medicaid qualification arrow. The final, let me just go over some final thoughts, because we're actually beyond our time. So for Heritage Design Law Group clients, they often face the situation that they become disabled and we need to help them manage their estate plans. There's something called the special delivery system, which actually, even though the client is not able to, is perfectly okay, and if they remain the trustees of their trust, we can have their helpers actually come in and attend the Step 2 programs for them, so that they can communicate what we're doing in the program to the clients who aren't necessarily able to make the program. We're considering doing some more direct work on Medicaid, but that probably won't take place for a long time. But one thing that's really important is that clients understand and their helpers understand that in terms of Medicaid planning, that we need not only current asset information, but income information, and that's information that we'll be getting during that process. Of course, our biggest frustration is to make sure that people actually call us when it's time to do so. So, that's the important part of the message. So, we don't have a helper listserv at the moment, but we're planning to establish one in the not too distant future. But make sure that you take a look at the website. We have the Blue Book and the Operator's Manual. We'll be providing the Helper's Manual, and there'll be a What's New section that you can log into and see as time goes by. So our 4 goals were so that you know the law firm name and our contact information, and remember that there is a process and that it's the process that produces the results. And we wanted to give you an idea of the kinds of issues that you'll be dealing with. We hope that we have done so, and in your evaluation, I hope that you'll let us know whether we've done a good job. And of course, we want to encourage our clients and their helpers to participate in the planning so that everyone is on the same page and things go smoothly as the clients want for the people that come after them. So 911, call the law firm. When there's an emergency, call the law firm. Locate the helper's handbook. We're going to be having that on the web, but if you come to the office, we can provide you with a hard copy. Locate the client's red book, and next, of course, relax. Remember that there's a dependable process that you can follow. Be sure to call early, and because if you call early, more options are often available for things like, for example, Medicaid planning, but it's important to get things started timely in order to make things happen. So how do we encourage the family to participate? Well, there's a settlement fee incentive because participation in the program means that estate settlement fees are vastly reduced beyond what the standard fees might be. There are disability and health care discussions, and there's the wealth reception planning that I mentioned a little bit earlier. So how do we do that? Well, the settlement fee incentive is already done. We have a fee agreement with our clients that we will provide estate settlement services for a certain fee. Now, please bear in mind that the successor trustees and the people who are actually making the decision about who gets hired to do estate settlement are not required to hire us. Our agreement with the client is that if people have participated in the Step 2 program, the estate settlement fees will be vastly reduced, and you can understand why, because we have clients and helpers who understand what their job is. We don't have to do a lot of educating, and we know where everything is and what it's worth, so that makes our job a lot easier, and so we can offer estate settlement services, particularly for disability, at a rate that's much lower. But remember, we can't require anybody to hire us for estate settlement. That is ultimately the decision of the successor trustees and the people who are making that decision, not us. Go for it in terms of making healthcare discussions. It's really important that those discussions be had while someone is well and able to do them. And we're going to be providing the inheritance training or wealth reception training for, that's a new program that we're going to be doing over the next year or so. So, are there any questions that people might have? I'm going to unmute everybody. Does anybody have any questions that they'd like to go over with us? Anyone on the call have any questions? Some of you, I think, have muted yourself. Judy, I can see that you are mute, but you've muted yourself. So you have to click on the right-hand side to make sure that you're unmuted. So if you have a question, feel free to speak up now.
I think we're good.
All right, great.
I'm done.
All right, well, thank you very much for attending. This has been, I hope this has been helpful for you. We'd like to hear from you about what your feedback is on it. Have a great day, and thanks very much.
Thank you.
Bye-bye.